Hey all, welcome back to the Law Read Slowly. In the last session, we were discussing written statement. We had almost completed the discussion on written statement. We had also seen how would you write the written statement and different paragraphs of the written statement. We also discussed that what goes into a written statement, and we discussed what would your written statement be if the plaint is one thing, and then what would the written statement say. We took a couple of examples of different paragraphs of that pleading of written statement, where we first pointed out that if your plaint says this, then your written statement is going to say this. And in discussing those pleadings of written statements, I did not just give you an example of pleadings. I also made a point to make you understand what each pleading meant, even if you have not discussed that topic or that law yet, like limitation law, etc. We still took an introduction to different kinds of pleadings that are usually raised in every written statement. So that when I'm giving you an example, an introduction to written statement, it's not just to tell you that, okay, written statement is the pleading of the defendant. No, written statement is a pleading of the defendant, but when we're taking examples of what these pleadings generally are, I have already explained to you and given you an introduction as to what are those general pleadings that you will find in every written statement and what is their actual meaning. Because what I could have also done is just told you that, okay, written statement is a reply to the plaint. So if plaint is saying this, then written statement will say this. If plaint is saying this, written statement will say this. But wouldn't have made any sense, because then even if these examples I would have made you write down, you wouldn't have understood what is that written statement actually saying. That's why we went into it and we understood it, and now in a fuller extent we know what a written statement does, because once you understand the concept, then you're able to understand how written statement tries to break everything in the plaint down para by para. Clear? Now before we proceed, now I told you this larger topic that we are grappling with right now is introduction to different things that we are going to use in deeper discussion of bigger complex topics of CPC. Plaint introduction is done, written statement introduction is done, cause of action discussion is completely done. Now moving from written statement, we have to look at certain terms which confuse a lot of law students because they don't understand the distinction between these terms, and they are terms which are part of every suit, every discussion of CPC. We will come to these terms today, we will discuss them, we will take so many examples on them that you will become a master on those terms. So what are these terms? It will be title, it will be a subject matter, it will be matters in issue, it will be relief, it will be cause of action. Cause of action I've already taught you. Relief you already know means whatever you're asking from the court. So our main focus is going to understand what is title, what is subject matter, what is matters and issue. If you ask anybody, generally people will feel underconfident to respond. If you ask them differentiate between these three, they will not feel confident, but I want you to feel confident because we will do it in such threadbare manner. We will take so many examples, we will discuss it over and over again that it will completely get ingrained in your mind. But you have to keep revising, because it's not like you have read something once and it's going to just stay with you. You have to repeatedly revise it. I do the same thing. If I show you, I have my notes on my table when I'm conducting your sessions, and I go through my notes even before sessions, because law is not something that it doesn't have any kind of affinity with you in the sense that it will stay with you just because you've read it once. It doesn't owe you anything. You owe dedication to it. So you have to keep revising it. I still revise it before taking sessions. So today we will get to those terms. We'll understand them in detail. We'll take a number of examples also. But before we start, we have to, as I promised you, we will read some relevant provisions which concern the discussions we have had so far. So my point was to first have the discussions with you, introduction to plaint, introduction to WS, and then in general that was an introduction to pleadings. And then I want to get into provisions, and now when we will read the provisions, you will see that it is just mimicking what we have already understood. Would I have taken you into provisions first, it would have taken us longer, because then I would have to, you would know nothing about what we're talking about, and suddenly I've plunged you into black letter of the law and you're trying to understand what is written in it. No. Instead, I chose to take you through another path, that first we logically understand how practically things are happening, how the law is functioning, and then we say where is that rule laid down in the law. So today we will be reading a number of rules from Order 6, Order 7, Order 8, based on pleadings, plaint, written statement. Now come to Order 6 first. We will not read these orders in entirety because there are so many topics in these orders, and we will discuss these orders in detail as topics in themselves. Right now, I want to ground you by reading only those relevant rules and provisions of these orders, which we have already discussed through our discussions on plaint, through our discussion on pleading, through our discussion on written statement. Right? Come to Order 6, Rule 1. It says pleadings generally. So Order 6 is about pleadings generally. So it is applicable to all kinds of pleadings. What all counts as pleadings? Plaint, written statement, your replication, that also comes under pleadings. They're all your pleadings. But if you see Rule 1 of Order 6, what does it say? Pleading shall mean plaint or written statement. So Rule 1 is saying pleading shall mean. When in law, whenever the word mean is used, it means that the definition is exhaustive. You cannot add anything more to it. So here you have to note that if you ask this question, for example, you're giving judicial services exams. In the prelims you're asked what is pleading, and then you're given 4 options in MCQs. And one of them is saying plaint or written statement. One of them is saying replication and rejoinder. Another one of them is saying set off and counterclaim. Then the 4th option is saying plaint, written statement, replication, rejoinder, full stop. Which one will you mark? Here, if it's only asking you pleadings include, then you will mark the 4th option, which is a comprehensive one. It contains plaint also, written statement also, rejoinder also, replication also. But the question is saying pleadings as per Order 6 Rule 1 means, then you will mark the option which is only listing plaint or written statement, or if it says plaint and written statement, then that is also correct. But the point is that if you learn the text, for exams like judiciary, you have to remember things like that. But if you are employing this understanding of CPC that you're gaining from here into any other kinds of exams, then you have to know that pleadings generally include all kinds of pleadings, not just plaint and written statement. But if a question being asked to you in any kind of setting is focused specifically on Order 6 Rule 1, then you will always pick the option of saying only plaint and written statement. Right? And I'm not making this out of thin air. If I read quickly, I just want to refer it to you so you don't have this confusion in your mind. If you come to Order 8 Rule 9, then it will say subsequent pleadings. No pleading subsequent to the written statement of a defendant. This much only. Point is to show you that the general meaning of the pleading includes everything, not just plaint and written statement, but any other kind of pleading also which is filed after written statement. And you can see Order 8 Rule 9 is talking about such pleadings which are filed after written statement. But if you say that no, because Order 6 Rule 1 is saying pleading is only plaint and written statement, then there is no scope for anything filed after written statement to be called a pleading. But Order 8 Rule 9 is calling them pleadings. It's saying that there is a scope that there can be pleadings after written statement has been filed. So don't bound yourself only by reading Order 6 Rule 1 and then say that no, only plaint and written statement is pleading and nothing else can be called a pleading. Pleadings can be a general term which you understand for civil procedure, but if you are being asked in exactly Order 6 Rule 1 explanation, then you have to explain it by only saying plaint and written statement. Clear? These things have to be very clear in your mind, because a lot of people who write to me with their doubts from these sessions, they say we are preparing for judicial services. Some say we are law students preparing for our law school exam. Some are also some young professionals. Now, if in law school exams also you get this MCQ that as per Order 6 Rule 1, pleadings are, then you will not mark the comprehensive option containing rejoinder, replication, etc. You will only mark the one containing plaint and written statement. But if the question is generic, pleadings include, then you can mark the comprehensive one. Clear? That was Order 6 Rule 1. Come to Rule 2 now. Pleading to state material facts and not evidence. If you only read this marginal note, the title of the Rule 2, then it's anyways clear. We have seen how do we write a plaint, how do we write a written statement. What were we writing over there? In every paragraph, we were just writing facts, the story. For example, if we wrote that a contract was entered into on this and this date, did we start copy pasting the whole contents of the contract over there? No. We wrote the facts Contract itself is the evidence. You will not put it in your pleadings. It will go in annexures and it will get proven at the evidence stage of a trial. You will not start proving it in your pleadings itself. Pleadings are only for you to tell your story, your facts. Every pleading shall contain and contain only a statement in a concise form of material facts. I've already told you, material facts. We took that example. If there's a contract, then will you be talking about the shirt that the parties were wearing to sign it? Or will you be talking about when the contract was signed and where was it signed? Material facts only you have to put in your pleadings. You can't drone about in your pleadings. A statement in a concise form of the material facts on which the party pleading relies for his claim or defense. What will be material facts? There will be facts which are important for you to plead in order for you to get whatever you're seeking from the court, the relief that you're claiming, or the defense that you're claiming from the court. So for example, we have done this a couple of times, so I shouldn't go into giving you examples now, but just for sake of clarity, we have done written statement. We have seen when the defendant wants to argue that this person does not have a valid contract with me in the first place, then there he will write the fact. What fact will get him the defense of there not being a valid contract between him and the plaintiff? The fact that the person with whom the plaintiff signed the contract was not his agent. So he will have to mention that fact. So this fact about that person, whoever the contract was signed with by the plaintiff, was not even the agent of defendant, becomes a material fact here. So he'll mention it, as the case may be, but not the evidence by which they are to be proved. But not the evidence. The evidence will not be attached. Now, plaintiff is saying that person C with whom I entered into a contract was the defendant's agent. Now, this A will not start copy-pasting the whole power of attorney that he has, which says that B is appointing C as his agent. No. He just mentioned the fact that C was the agent of defendant B, and that is why defendant B is bound by the contract that I have entered with his agent C. Subrule 2. Every pleading shall, when necessary, be divided into paragraphs. We have done that. Numbered consecutively. We have done that. Each allegation being so far as is convenient contained in separate paragraph. We have done that also. So we weren't like writing half of. So for example, if we're writing readiness and willingness of the plaintiff to perform the contract, then were you starting it in one paragraph and then ending it in another? No. We made one paragraph in which we completed this whole point about readiness and willingness of the plaintiff to perform the contract, which is one of the things required to fulfill the cause of action under specific relief act for specific performance of a contract. Subrule 3. Dates, sums and numbers shall be expressed in a pleading in figures as well as in words. Self-explanatory. Rule 3. Forms of pleading. The forms in Appendix A, when applicable, and where they are not applicable, forms of the like nature, like character, as nearly as may be, shall be used for all pleadings. Clear? We have stressed enough upon this ever since session 1, that appendix and the appendices are not there for just the sake of it. You are required to follow them. We have already looked at that specific rule in CPC. It's your job to go back in your notes and find out. I'll give you a hint. That rule was contained in an order which fell after Order 40. So go find out that rule. That order, it was an order in which there was a rule which clearly says that any appendices that are provided in CPC have to be followed. They can't be relegated away. And same thing Rule 3 is saying here, that when you're drafting your pleadings, first go look at the appendices that are provided in Appendix A. If you sit in your own time and read that Appendix A, you will see so many examples of pleadings for different kinds of suits. It's very interesting to read the Appendix A because it tells you different kinds of suits and then it tells you what kind of pleadings can be made in every suit. So that's why it brings us to the point that CPC is very thick. This thickness is in your favor. So even if you don't know anything about CPC or civil procedure, you can just read CPC and it will make you a decent human being who knows civil procedure. Rule 4. Particulars to be given where necessary. In all